Right, Mr. Dawa?
As the court proceeds, my lord.
Could you be a bearer of good tidings?
I need to clarify. Let me recall the matter first, my lord.
All right.
SS 165 163 of 2015.
Right.
Thank you, my lord. My lord, there are certain issues that we discussed during the adjournment, and certain undertakings have been taken. Perhaps when I reply to some of the submissions by Mr. Van der Merwe, I will indicate to the court that this has been settled, or what is the position.
Yeah, that would be very proper.
Thank you. Then,
with regard to what you were to deal with during the tea adjournment, were you able to?
Insofar as my lord can remind me.
I'll tell you now.
5.5.
There was mention of that was mentioned whilst you were dealing with 5.7.
5.7 as well.
Yeah.
Oh yes, my lord.
And then 5.7, and when you were dealing with I think it was 6.2.10, somewhere there. When you were dealing with paragraph 64, page 32 of Uchan case.
Well, I just made submissions there, my lord, and I'll stop there. Yes.
That's okay.
That's okay.
Okay, fine, that's all right.
And my learned friend. 5.3 and 5.4 pertaining to the cellular records.
Oh, yes.
5.3, 5.4 is on page 12.
Yeah, no, that's very true. That's very true. In fact,
The first aspect.
it's 5.3 and 5.4 and then 5.7. Sorry, yes, 5.7, yes.
Correct, my lord.
Okay, just a moment. You indicated that you've been in communication and that you are still to meet with regard to certain aspects. Could that be referring to 5.3, 5.4, and 5.7, if you were to give an indication?
Yes, my lord. 5.3 and 5.4. I think we are at EM with
You are happy.
We are happy.
Are they settled?
They can be considered settled.
Okay, that's the.
That's pertaining to accused number 4.
Thank you very much. And then we get to 5.7.
I have indicated to my colleagues that a request has already been made to the Chief Minister Magistrates Court.
That relates to, is it the record of the bail application?
The bail application, yes, my lord.
Okay, fine. So then we needn't worry ourselves.
We didn't worry about it. As soon as I get same, I'll make copies and
okay.
And hand same to my colleagues.
Okay, just a second. Is that the Jamestown Magistrate Court?
That is the Jamestown Magistrates Court, my lord.
Thank you very much. You see, you've made headway.
Thank you.
We have indeed, my lord.
Thank you. Thank you.
We'll have a discussion, my lord, maybe on the next break as to now following 87.2, insofar as 5.7 is concerned, because 87.2 says same must be entered on record.
Oh, okay. Right, thank you.
Thank you, my lord. My lord will see that on 6.2 up to 6.2.11,
Yeah,
the reply is the same, that reference will be made to paragraph 1 and 2 of part A of the summary of substantial facts, and the state further submits that this is a matter of evidence as indicated on the paragraph I've mentioned. I was about to deal with 6.2.11 to actually illustrate why I'm saying this is a matter of evidence.
6.2.11.
0.11.
All right, fine.
The state is requested to indicate the role, I think you wanted to say the role,
Yeah,
of each and every accused in respect of each and every charge, and in addition thereto, the state specifically with reference in respect of every charge, if the respective accused was a main perpetrator, co-perpetrator, accomplice, accessory after the fact, accessory before the fact, and an accessory after the fact. It is my respectful submission that supposing what the witness might come and say is dangerous. That is why Judge Erasmus says we should guard against that. To order the state to come and say, tell us who's the main perpetrator, tell us who's the co-perpetrator. More especially, my lord, in circumstances where we are not facing only one charge. There are a number of charges. And I will make an example. We count one. If I can just get my enlightenment. This is a contravention of the Rioters Assemblies Act. All that is needed to prove this charge is that there was a meeting of the minds. I need not expatiate what Cooper is saying, insofar as whether whatever the intention was, whether it materialized or not, is irrelevant, according to what Cooper is saying, insofar as the conspiracy charge is concerned. Whether the meeting of the mind is that's sufficient. That's the method the court is going to hear when you make submissions after evidence has been laid. Bearing in mind that the replies to further particulars are binding to the state, why do you want the state to give you its inferences, which is not going to assist the court to come to a conclusion? The court will have to make its own inferences based on the proven facts. Hence, my lord, it's my respectful submission that this is the matter of evidence. With that, my lord, that concludes my reply insofar as accused number 4 is concerned. Unless there's anything else that my lord wants me to address him on insofar as what accused number 4 is concerned, I would request to move to accused number 1, 2, 3, and 5.
right, I think you can gladly do that.
As a court wishes, my lord. The same request starts on paragraph 16, rather on page 16 of the bundle. I like the manner in which this is drafted. More especially the last paragraph on page 16. And whereas the state supplied the defense with documents on 3 May 2016 alleging the involvement of the accused in certain activities. I will revert back to this during my submissions. Now, if you go to page 17, add count 1, 1.1. once again, we need to remind ourselves, it's my respectful submission, about the provisions of the section 87(1). An accused may at any stage before any evidence in respect of any particular charge has been laid, in writing request the prosecution to furnish particulars or further particulars of any matter alleged in that charge. And the court before which a charge is pending may at any time before any evidence is in respect of that charge has been laid direct that particulars or further particulars be delivered to the accused of any matter alleged in the charge, and may, if necessary, adjourn the proceedings for such charge to be delivered. Now, 1.1 reads.
Maybe before you proceed, if I could possibly ask this, directing the question to both of you, Mr. Van der Merwe and yourself. Just as it was done in respect of case number 4, could there be any matters which can be regarded as settled insofar as the request and the replies are concerned?
Perhaps, my lord, I think it will be advisable that we take a brief adjournment.
Yeah.
I think that would be a good idea, and then we can sit down and quickly pick up. And
that's very true, because in that event, you will realize you will not have to deal with things that you are, which you don't have to deal with.
As a purpose.
By agreement.
As a purpose.
Right. Shall I wait, sir?
My lord,
or how far do you want me to go?
My lord,
go back to my chambers?
To your chambers, my lord. We'll let you know.
I'll do so.
Thank you.
Thank you. The good idea.
Quickly also just deal with the photographs.
Other people. Yeah, that's what I told him. But he didn't ask for them. You did. You didn't ask for them.